let me call this one. State of Nevada versus Kimball Austin Sachs, case number C343540. And case number C343540, State of Nevada versus Yuxia Zhang.
Megan Thompson for the state.
Charles Goodwin, 14879 for Mr. Sachs.
And Jess Marchese on behalf of Mr. Sachs, here to accept the appointment.
And then Mr. Shetler.
Shetler, 47 for Zhang.
Okay. And we've got Mr. Sachs and Ms. Zhang are both present on the line. All right. This
And
is
Judge, I am here. Dena Rinetti for the state.
Ms. Rinetti is there as well. All right. Okay. All right. We've got a couple of different things going on. We have we've got a motion to withdraw that was filed by Mr. Goodwin. However, Mr. Goodwin did file a motion to reconsider the bail that the court had imposed at the last hearing, the increase in the bail. And so I think before I allow you to withdraw, just from a procedural standpoint, I should probably have you argue that motion and then hear the motion to withdraw. And then I had Mr. Marchese come in because if the court is going to allow you to withdraw, I wanted to make sure that we didn't have anything that was not seamless as far as getting new counsel appointed right away for Mr. Sachs. So that's why I brought Mr. Marchese here, but I wanted to make sure that we do this in an order that makes some sense. I did receive a phone call from Mr. Shetler's office in regards to the documents, the addendum number 1 and the addendum number 2, and whether or not the court had read those documents. I do understand that there was an issue as far as the arrest and detention of both Ms. Zhang and Mr. Sachs on the, I believe it was the 26th that happened.
I believe so, Your Honor. Last Friday.
And so they had put in their addendum number 2 that they wanted answers from this court. Quite frankly, I don't have an obligation to answer to them, but I did receive the answers. So we can discuss that, but that seems to me to be the direction that we should go down this as far as approaching this, unless anybody else has a different idea.
Well, Your Honor, part of the reason for the motion to withdraw is over this motion to reconsider bail and those arguments, because in my opinion, the issue of the bench warrant and the no contact order was settled. And my reading of the record was that the increase in bail had nothing to do with the motion or anything like that. So if this is an issue that I'm having with Mr. Sachs, is that I don't believe that that's an argument that needs to in any way be put forth. I don't think that it's relevant to this. And that's why I did not file that or have that addendum on mine. So I don't know if the court would like me to argue this motion, or potentially before allowing Mr. Marchese, have Mr. Sachs, because he's very, very persistent about that specific issue about the warrant the warrant should have never been issued is his position. Thus, the bail increase is illegitimate. That is, I do not feel comfortable making that argument. So if the court would like me to do it on the papers that I filed, I'm happy to do that. If the court would like me to make the argument for the position that Mr. Sachs would, I am happy to do that as a friend of the court, but I don't think that that argument carries a lot of water, personally. Alternatively, Mr. Shetler can make that argument. It's just my concern is that I don't think that there's any legal basis to think that. I'm sorry, Your Honor.
You're fine. I guess then I would simply ask the question, if you didn't believe that it was a valid motion to file, why did you file it?
No, I'm sorry, Your Honor. Based on his inability to pay, I think it is valid. I
Oh,
think that the issue with the detention order, but the
Oh, okay.
other portion that about the addendums that Mr. Shetler filed in and those types
Gotcha.
of things, that section, Mr. Sachs was very adamant that this be argued today.
okay,
And I don't believe that that argument, so that's why I didn't file that. I'm
Okay.
fine arguing just on that point, but I know
Okay.
Mr. Sachs wants to bring up the issue about the bench warrant not being a legitimate bench warrant in the first place.
gotcha, okay. So why don't we do this then? Why don't you do the motion to reconsider the bail? And then I will allow you to argue your motion to withdraw. And then we can address those two things and then we can move forward. So I will hear from you on the motion to reconsider bail.
Sure. So, Your Honor, I think it's fairly straightforward. The court did not seem to intend to imply any kind of detention order. It means that the court did not have an issue with Mr. Sachs being out, believe that there were least restrictive means available to him to be out. Currently, with his financial situation, due to the length of this case and his inability to find work and other things like that, it has actually placed him in a position where he is well below the federal poverty line. And in fact, it's essentially presumed by the fact that I am his counsel that he's having appointed counsel. The $10,000 increase is above and beyond what he can reasonably get together. He just doesn't have the means to do that. As such, it's becoming an effective detention order, meaning that if he can't make that $10,000, then he's essentially stuck in a position where the warrant's going to be reissued and he's going to be in custody. So with that being a detention order, I believe that what we would have to do is move to some kind of hearing where there'd have to be clear and convincing evidence that there is no least restrictive means to allow him to be out. And I don't think we need to go that route. There were some further conversations, and my understanding is that Mr. Sachs at this point is stating that he cannot make any kind of bail increase. I know I put one in the motion. That was what the original conversation was about. But I think that at this point, he's not able to even get that much put together. So the issue that we're facing here is whether or not the court believes that Mr. Sachs should not be released, because that's the real question that's in front of the court with his inability to pay. And with that in mind, I don't think that there is any reason to believe that Mr. Sachs is not going to appear to court. And I don't believe that monetary would satisfy any other concerns concerning the no contact or anything on like that, because what we're doing by placing a bail there to control behavior is saying, if you're rich, please feel free to do what you would like. So in my mind, when you're increasing bail, it comes more to the ability to show up to court and whether or not you're going to be here. He has always participated. He has always been a part of everything. So I don't know if there's any real reason to increase this bail. And I don't believe that it's warranted in this case based on his inability to pay. Mr. Sachs did send me tax returns. Mr. Sachs wanted me to file them. I didn't feel it was appropriate to file those, but if the court would like to review those, I've got his tax returns and can get those tax returns that would show that he does not have the monetary ability to make this payment.
Well, and to be clear, at the last hearing, I believe that this court actually made a finding that I was not increasing it based on the violation of the no contact order with the child. What I was basing it on was the fact that we did not know where they were at, that they had placed signs in their front yard indicating that they were no longer at that home, and that based on that I did consider them to be potentially a flight risk at that point, especially since there was an order in place as it pertained to Ms. Zhang that she could get her passport back. I understand that she hasn't yet, but those were the concerns that the court raised. And so when I'm looking under Valdez Jimenez as to what is the appropriate bond amount, I'm looking at detention can only be justified by clear and convincing evidence of flight risk or danger to the community. And the court had the concern of them being a flight risk. And so that's why I had increased it. I do see, based on them being on Zoom and the pictures that I have seen many other times before that they have appeared on Zoom, that it appears like they are back in their home. I recognize the fact that since they were detained, they were obviously still in Arkansas and picked up by the Arkansas police. So I don't think that based on that I have as much of a concern as them being a flight risk or a danger to the community anymore. Obviously, I had a concern of danger to the community if we're considering their son part of that community because he had been taken previously before by CPS. And while I understand that there was at least a good faith argument to be made that that order expired by its own terms, I don't think that that was fully briefed 100%. And as the court said at the last hearing, there was still a CPS order, to my knowledge, still in place that he was not supposed to have contact with the child. So even if there was an order from this court that would have expired regarding the no contact, there was still arguably a CPS order that was in place regarding the no contact. So I think that if we look at from that perspective of they wouldn't allow the child to be seen, they spirited him away on a flight back to China without anybody laying eyes on him, to the extent that the child is part of the community, the court did look at that as being a danger to the community. So those were the two reasons that I increased the bail amount. To the extent that the child is now back in China, that we now have an order in place that from this court that specifically imposes the no contact, and the fact that they are now both back in their home, I don't think those concerns are as much of concerns anymore. And so therefore, on that basis, the court was inclined to grant your motion. But I will hear from the state, understanding that I did read your opposition, Ms. Rinetti, and I think I explained thoroughly why I'm inclined to do what I'm going to do, but I will certainly still hear from you for purposes of making your record, Ms. Rinetti.
I think the record's been made by my written opposition, the state's concern regarding the safety of that child, and no assurances really that at any point that child could be coming back to China. And time again, we have seen that they have violated that no contact, whether through CPS or through the court system. And so that is the state's great concern. And based upon, I think the court is well aware through other court dates about all the behaviors that took place in Arkansas that were concerning to the state, both from a law enforcement's perspective as well as a child protective services perspective.
And I think that we now, to the extent that we now have an order in place that is a no contact order that can be renewed every 120 days until this matter resolves itself. I think that the defendants have been placed on notice that they are not to have contact with that child, and any further violations of that court order will result in this court taking very serious action. So with that, I will grant the motion. And I will keep the bond amount at the $10,000 that it is currently at. The additional condition of the no contact has already been imposed by order, and so I think that that resolves those two issues. As it pertains to the motion to withdraw, we've already had a young hearing. We've already tried to remedy the relationship between yourself, Mr. Goodwin, and Mr. Sachs, based on your affidavit. I don't know that it is necessary when we've got a party who clearly does not want to have you as their attorney anymore, and clearly you do not want to be the attorney anymore. And I think that that is enough to establish that there is a breakdown in the attorney-client relationship that makes it impossible for you to continue. I don't know that the court needs to hear more. I understand that there are discussions that were had that you do not want to get into because you believe that it would violate attorney-client relationship and confidences that were contained within that attorney-client relationship. I don't know, absent me hearing from Mr. Sachs, and I will leave it up to him because he has a right to be heard. So, Mr. Sachs, would you like this court to grant Mr. Goodwin's motion to withdraw and to appoint Mr. Marchese at this time?
Yes, please. Thank you.
All right. Mr. Goodwin, you are, your motion to withdraw is granted. Mr. Marchese, you are confirming today?
Yes, sir.
All right, Mr. Marchese, you are appointed to this matter. I don't
Excuse me.
know. I think that deals with everything that Mr. Goodwin needs to deal with. Mr. Shetler, your turn.
Thank you, Your Honor. You know, I know that you've read these items. I know that this is a department that is all more prepared than anybody else in the room. I can't disagree with the statements made by Mr. Goodwin. I don't think that some of these matters are for this court, but I wanted to be clear that my client's position was heard.
Yep.
And I want to be clear that based on what you just did by reinstating the previous bond, the only other issue that I really have today I can't address because I want to make sure the current status of the CPS bond, that's unrelated, I think, to what we're doing here today. The order, if it exists, my clients are unaware of it. So I want to follow up on that. And if I need to, I can revisit it then. But I do. And I also want to say this. It's hard for me to shut up sometimes, Judge. You have, that is not your, in your bailiwick to have to get into that description of what happens with the sequela of the warrant. I understand from your comments, you do have some information. I know that my client is very, very curious to hear that. I'm happy to address other issues, but in light of what you've done, I don't know if there's anything else that I feel like I can add today until I know more about the CPS orders.
So, and I don't know if there is an active CPS order out there or not. My point is that your clients were clearly aware by the fact and the virtue that that their son was taken by CPS, placed on a plane to China, and that there was nothing changing that result, that they at least had an implied awareness that they were not to have that child. And so, based on that is why this court originally issued the warrant that it did. However, and this, I think this is all I'm going to say about this, and I will say nothing more about this. On the date that we heard the motion to quash the warrant, which was September the 17th, that motion was granted. On that day, the clerk in my court clerk, not my law clerk, my court clerk, went into the warrants tab and then that warrants tab gets sent over to NCIS. That was accomplished on that day. What happened in the interim between the NCIS data board and NCIC data and Arkansas, I do not know. That is beyond my bailiwick. That is beyond my purview. I have no way of knowing that. I do know that the day that they got picked up, I immediately received a phone call. An order was sent over to me. I signed that order within a half an hour, which is why they ultimately were released as quickly as they were, I believe. So, but we did everything on our end that we were supposed to do.
Thank you very much, Judge. I appreciate that.
Okay.
Excuse me, Judge, may I just ask the question of new counsel's name to get his spelling correct and his telephone number, please?
Yes.
You're not gonna get my cell phone number, but I will reach out, sir.
Okay. And it's Marchese, Marchese, correct?
Correct, Your Honor.
All right. And so he will reach out to you. Okay.
May I ask reasonably when he's going to reach out, Judge, please?
Within 24 hours.
Thank you, sir.
You're welcome.
All right. Anything else that we need to do on this matter for purposes of today?
No, Your Honor. Thank you.
No,
Thank
Your
you
Honor.
very much.
For Ms. saying the bail reconsideration is the same as.
Yes, yes. So the bail will stay the same for Ms. Zhang as well as for Mr. Sachs at the $10,000. And the no contact order with the child has already been entered in both cases. Thank you very much
Thank you.
for coming down, Mr. Marchese.
Mr. Goodwin is preparing this file for me.
Thank you. I appreciate that.